With a stay staying in place, the district judge in the gun ban challenge filed an amended judgment and a permanent injunction. Welcome in Illinois in Focus Daily. I'm Greg Bishop. We've been tracking the gun ban litigation really since before it passed in 2023, in January, after lame duck session. Obviously it bans more than 170 semi-automatic firearms, from rifles to pistols and shotguns. Prohibits the sale and possession of magazines over certain capacities for handguns and for rifles. Also bans a bunch of attachments, requires people register previously owned firearms. But shortly after it was enacted, you had cases filed. All the cases in the Southern District were consolidated. You had cases in the Northern District challenging local and statewide bans. But obviously we're here now after permanent injunction was issued last month by the district judge. The appeals court now has the case, but the appeals court in the case said that the ruling from the judge in the district court was deficient. And then you had the back and forth about whether to send it back to the district judge to get a clearer order, or also another question the appeals court asked was whether a stay should be issued, because when District Judge Stephen McGlynn issued his permanent injunction against the law from being enforced, he issued a 30-day stay, and that was lifted after the appeals court a few days before the 30-day mark went ahead and issued a new stay. So with that stay in place, District Judge Stephen McGlynn did issue an amended judgment and a separate permanent injunction against the law. So let's go ahead and pull that up here with Illinois in Focus Daily. These were filed on the 10th, so just a couple of days ago here, keeping you updated on the very latest. So let's pull this up from the federal court in the Southern District, the Barnett v. Raoul case, and we'll just read through this. This matter's come to the trial before the court, and the court having rendered its decision. Continue on here. It says it's hereby ordered and adjudicated and judged that the clerk's judgment issued November 8th is vacated. It is hereby ordered and adjudged that counts 4 and 6 of the Langley plaintiff's complaint are dismissed with prejudice in accordance with the court's finding of fact and conclusion of law. Langley, with attorney Thomas Magg, had a couple of complaints against the law dealing with the Fifth Amendment issues, and I believe also vagueness issues, and those were essentially put to the side to tackle only the Second Amendment and 14th Amendment issues. So will those complaints come back in the future? I don't know. I guess we'll see. Meanwhile, the amended ruling here from Judge McGlynn says this court holds the Protect Illinois Communities Act is unconstitutional in accordance with the Second Amendment and the United States Constitution as applied to the states by the 14th Amendment in accordance with the court's findings of fact and conclusion of law, and that a permanent injunction is required to protect the rights of citizens of Illinois. Therefore, it is hereby ordered and adjudged that the following plaintiffs' request for declaratory judgment and for a permanent injunction is granted. And it goes through the various plaintiffs that were part of this case: Barnett, Harrell, Langley, the FFL of Illinois. Additionally, due to the unconstitutionality of the Protect Illinois Communities Act, judgments entered against the following defendants: Barnett, Harrell, with Raoul and state police involved, and so on. In accordance with the rule of Federal Court of Civil Procedure and citing a case, this court's issuance of a permanent injunction relief is addressed by a separate order. Then you have Judge McGlynn signing that. So that's the amended what do they call this? The amended judgment in a civil action. Now we get to the separate filing here, which is the permanent injunction that McGlynn issued on, Tuesday. It says that pursuant to the rule, the court orders the following permanent injunctive relief. It's hereby ordered and adjudged that the state of Illinois is enjoined from the enforcement of the Protect Illinois Communities Act, specifically from enforcing the criminal penalties in accordance with state law, bump stocks and assault weapons and attachments, and large capacity magazines against all Illinois citizens. The state of Illinois is also enjoined from enforcing the firearm registration requirements and penalties associated with entering false information of the enforcement affidavit for non-exempt weapons, magazines, and attachments previously required to be registered in accordance with the law. In accordance with the order issued December 5th, 2024 by the Court of the Appeals of the Seventh Circuit, this injunction is stayed until the Seventh Circuit has issued its mandate. It is so ordered. So Judge McGlynn doing what the appeals court requested to get a specific, injunction issued. And that specific injunction isn't just for the plaintiffs in the case. It says, and we'll take a look at it again, the state of Illinois is enjoined from enforcing the registration requirement, but also the state's enjoined from enforcing the penalties against all Illinois citizens. But it stayed. So Judge McGlynn's order will be addressed in the appeals court when we see the filings in this. When we're going to see a hearing in this, as we talked with the Illinois State Rifle Association earlier in this week, you can see that segment. Ed Sullivan believes that March is a big time. If we can get this heard and decided by the appeals court before March, then you could possibly get it in front of the U.S. Supreme Court. But he's not confident that's going to happen and thinks this could possibly be a 2026 case, especially when you look at some of the other cases challenging Illinois' gun ban. I believe the Beavis case, which challenges the state's ban and Naperville's ban, that was filed back in November of 2022, I believe, a few months before the state's gun ban went into effect. And it's back in the district court after preliminary issues dealt with, and they've got a schedule that stretches all the way into like August of 2025, just for the district court. So how's this going to play out in the appeals court with the state's proposed order here? Or it's actually a filed order. It's force of law, but it's stayed pending the action of a superior court, the appeals court. But clearly a lot of moving pieces here, and hopefully this is helpful to get that play-by-play and step-by-step of how this is impacting Illinoisans. It is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Wake up with us each and every weekday morning as we break down things you need to know to get your day going here with Illinois in Focus Daily.